The death certificate format, if you see very clearly in various municipality area, are very clear domain. If you are in metropolitan city in a municipal areas, yes, you have got a certificate provided by the government. Now, what are the purpose of this? Every government wanted to know that which disease are causing a death in a human for making a policies or making a new investment in particular health sector. For the purpose of that, death certificate is a very important document, because once you write the cause of death, it will go to the medical officer who is duty bound to segregate all the things. The registrar is going to segregate all the things to find out which are the diseases causing much death. If it is diabetes mellitus, or if it is acute MI, or it could be malaria, it could be typhoid. So they will plan a scheme to control such a disease. For that, death certificate is given. So if you see the death certificate, there are a few pointers very clearly mentioned. One is immediate cause of death. Now, immediate cause of death is very important part, and that you need to write properly. Cardiorespiratory failure cannot be always be a reason for cause of death. So you need to be very specific. If it is septicemia, write it septicemia. Subsequent cause, then mention subsequent cause, diabetes mellitus, infection, gangrene, whatever. If it is cardiac arrest, mention subsequent cause. Could be carcinoma, could be any impied disease, or could be ISD. If you write acute MI, then it will be related to something. If you write, cause of death as a some cause of death which relate to perforation or some derailment of a lipid profile, or could be my suggestion that the cause of death should be a cause of death, immediate cause of death. What can lead to death? And then subsequent cause. Old age cannot be a cause of death. Many of the time I found that various certificate they mention old age. Old age, can you define the old age? 95 years or 67 years. Can you define? Supreme Court said that average life is 67 years. Can after 67 you can write it old age? Old age cases that came to me. I have got a case of 100 years, 98 years. Guy died, death certificate issued by the doctor, challenged by the sister who was living abroad. Her daughter came who challenged the filed a complaint. My doctor have to face a trouble. So don't ever write such an ambiguous word which cannot be justified in court of law. So when paper comes to you, you need to be very clear that what exactly need to mention. Don't ever give a certificate by taking something and writing from the patient that I don't want to go for the postmortem, so that I request a doctor to give the certificate. Please, please don't indulge in such a thing. Anything taken in written in writing against the law, against the act, is null and void. I'll give an example. For the same patient, you have advised postmortem. Why you advise postmortem? Because you are not aware of the cause of death. So you said to the patient, take it to the postmortem. And once you got influenced, request by this patient, and then give in writing that we don't want to go for the postmortem, doctor suggested us, but we don't want to go. Suddenly you become a god and you realize, no, this is the cause of death. So one side, when you say that I don't know the cause of death, second side, when you say that I know the cause of death, is a contra-integrity, absolutely contrast to each other. Please don't indulge in such activity. My humble request to all my friends listening to me, your degree is very prime. You have been respected in society like a god. So don't do any act which can lead to trouble or any other scenario which can really ruin your reputation. That certificate is one thing which we all need to remember, how important it is. You can be very well defended in court of law under RBD Act for good faith. You can be very well defended in court of law under the word of belief, under the word of best of your knowledge. So never ever worried that if at all you have written a wrong diagnosis, you will be troubled. You can be protected by good lawyer in the country. Yes, good lawyer. Always prefer medico-legal lawyer practicing in a court, because they are different than the normal theoretical lawyers. And always give your case to best hand friend. If you're the doctors is medico-legal services, even if at all I'm charging lakhs of rupees to the direct client, my service is free of charge. Being a Supreme Court lawyer and High Court lawyer, I am absolutely freely available to all the members of doctors medico-legal services, even if you paid 8,000, 5,000, 10,000 for a year. I'm talking about a year. All professional indemnity policy costs not more than 500 rupees a month. So even 6,000 rupees you paid for the policy per year, or 12,000, depending on the specialty. If it got anesthetic, it could be 20,000 for 1 crore, less than what you paid. Surgeon, it could be 10,000, 12,000 per year. But in a year, you are getting a good lawyer. Even one notice you will send through this company, your 10,000 is recovered, friend. So it is a wise decision to take a decision of being a part to doctors' medico-legal services. By taking indemnity policy and services, you can be protected everywhere.